15 of Law and Batting Order. I'm your host, Tony Iliakostas. Here are some quick hits from the past week. The Dodgers have new owners thanks to a little touch of magic. On Tuesday night, Los Angeles Lakers great Magic Johnson and his investment group purchased the Los Angeles Dodgers for, get this, $2 billion. That's right, billion with a B. The purchase of the storied franchise marks the highest purchase of a team in sports history. If you recall, former Dodgers owner Frank McCord lost ownership of the team after an ugly divorce with his wife. He was also unable to strike a TV deal with Fox Sports that would have allowed him to retain ownership of the team. Magic Johnson says that he will play an active role as owner, but that his right-hand man, Stan Kasten, will make baseball-related decisions for the club, given that he is a longtime baseball executive. Hopefully, this purchase will revive a winning culture for the Dodgers. New developments have come out of New Orleans this week. If you recall, last week, the NFL punished the Saints and other entities, including Saints head coach Sean Payton, for their involvement in a bounty fund between 2009 and 2011. This Friday, Sean Payton filed an appeal with the Commissioner's Office after he was suspended for 1 year. It will be up to NFL Commissioner Roger Goodell to sustain, decrease, or remove Payton's suspension. In the case that Payton's suspension stands, a search for an interim coach is already underway, and one name that floated around is the great Bill Parcells, who was Payton's mentor when Payton was the Dallas Cowboys coach under Parcells. This March has been utter madness in the world of men's college basketball. March Madness began with 64 teams, and now there are 4 teams contending for the championship title. The teams advancing in this year's Final Four are University of Kentucky, Louisville, Ohio State, and the University of Kansas. At the time this was filmed, I won't know who will be advancing to the national championship game, but it wouldn't be a surprise to see John Calipari's Wildcats take on the Sooners in this year's college basketball championship game. Today's Order in the Court will be discussing the possible appeal that former University of Virginia men's lacrosse player George Huguely will file after being found guilty of second-degree murder for the death of his former girlfriend, Yardley Love. I talked about this topic a few weeks ago, which you can see by clicking the annotation on the right-hand side of the screen or by clicking the link below this video. Briefly, the facts are that on May 3, 2010, Yardley Love was found dead, lying in a pool of blood, and was ruled to have died from blunt force trauma to the head. George Huguely was brought in by police for questioning, and he stated that he was involved in an altercation with Yardley Love, and that during the course of the altercation, he shook Love, and her head repeatedly hit the wall. There were also claims that Huguely drank excessive amounts of alcohol in the weeks prior, as well as on the night of Yardley Love's death, which may have been a contributing factor to Huguely's actions. Based on the evidence presented at trial, the prosecution was able to prove beyond a reasonable doubt that George Huguely was guilty of the death of Yardley Love, that is, of second-degree murder under Virginia's homicide statute. It is believed that Huguely could face jail time of around 26 years. About 2 weeks ago, there were reports that George Huguely's attorneys will appeal this decision. To appeal a case, the defense attorneys must prove that there was either a legal error, juror misconduct, ineffective assistance of counsel, or some other error, procedural or otherwise, committed at trial that contributed to the outcome of the case. To grant the appeal, the appellate court must find that these errors affected the outcome of the case. This is as much as I know about the facts of this case, and it's too early in my career as a law student to further opine on the criminal appeals process. But let's assume for the sake of argument that the appellate court finds that there was an error at the trial court level and decides to overturn the decision and grant a retrial. What could Huguely's attorneys possibly argue if, in fact, there is a new trial? This is the topic of today's episode. The goal of defense attorneys is to argue that their client committed the least offensive action possible. Defense attorneys are advocates for their clients. They humanize their clients and they try to detract from them as much negativity as possible. In this case, Huguely was originally convicted of second-degree murder. If the appellate court were to grant a retrial, Huguely's attorneys must argue during a potential second trial that their client committed either voluntary manslaughter or involuntary manslaughter, and that the prosecution did not meet the burden of proof. Of course, the ultimate goal is that their client can be acquitted, but the more realistic goal is to try and mitigate Huguely's conviction from murder to manslaughter. Virginia does not have a voluntary manslaughter statute, but Virginia common law has defined the elements of voluntary manslaughter. The case of Barrett v. Commonwealth states that to reduce homicide from murder to voluntary manslaughter, the killing must have been done in heat of passion and upon reasonable provocation. In other words, Virginia's voluntary manslaughter rule adopts the common law rule of adequate provocation. The adequate provocation doctrine states that the defendant was adequately provoked, had no time to cool off, and committed the act in the heat of passion. However, an adequate provocation defense, according to the common law, can only stand if the adequate provocation is reasonable. There are 5 reasonable exceptions of adequate provocation under the common law. They are adultery, mutual combat, assault and battery, resisting illegal arrest, and injury to relative. There is credible evidence that Huguely was adequately provoked by Yardley Love when there were claims that she was cheating on him. Perhaps the allegations of cheating enraged Huguely and made him go wild on Love. However, this is not enough to satisfy an adequate provocation defense. None of the adequate provocation exceptions truly apply here, so it would be incredibly hard for Huguely's attorneys to argue an adequate provocation defense. However, it is possible that Huguely's attorneys argue that their client should be found guilty of involuntary manslaughter. The Virginia Annotated Code section 18.2-36.1b reads as follows: if the conduct of the defendant was so gross, wanton, and culpable as to show a reckless disregard for human life, he shall be guilty of aggravated involuntary manslaughter, a felony punishable by a term of imprisonment of not less than 1 nor more than 20 years, 1 year of which shall be a mandatory minimum term of imprisonment. Huguely's attorneys could argue that on the night of Yardley Love's death, George Huguely acted wantonly such that he showed a reckless disregard for human life. Remember that the mens rea term of recklessness is a conscious disregard of a substantial and unjustifiable risk that is a gross deviation from the standard of a reasonable person. Here, it could be argued that Huguely acted wantonly by drinking excessive amounts of alcohol the night of Yardley Love's death. It could be further added that he knew his heavy drinking habits could lead to dangerous results, but he carried on anyway. His excessive drinking led to his rage, which could be evidence of his reckless disregard of human life. The fact is that no one knows what his rage could lead to, but in this case, we do know that Huguely's anger led him to shake Love violently after blasting through her apartment door, and by hitting her head repeatedly on the wall, her death ensued. This defense could stand, but it all depends on whether or not the Virginia Appellate Court decides to overturn the original conviction and grant a retrial. If so, this is the defense that Huguely's attorneys will consider as they seek to mitigate George Huguely's murder charge if appropriate during the second trial. That's the show. Leave all your comments down below and be sure to visit Law and Batting Order at lawandbattingorder.com as well as on Facebook and Twitter. Till next time, have a great week, guys.